Very, very warm welcome, everybody. It's great to see all of you here today. Some old faces, some new faces, and some late faces who I'm sure are going to join us as we go on. This webinar today, Think Legal Children's Court 101, What to Expect. I really look forward to hearing from Leigh Govender, who I will formally introduce a little bit later as we go on. So from my side, let's go into the housekeeping. My name is Mervyn Vermeulen. I am your host for today, not your presenter for today. I'm going to take you through the housekeeping issues, and I'm also going to moderate the chat box as we go on through this session. House rules and etiquette, for those who have joined us today for the first time in one of these sessions, please do use your real name for register purposes. It does get a bit awkward when we have to deal with Strawberry Lips 57 and trying to answer formal questions in that manner is not always ideal. So please do use your real name for register purposes. Please feel free to type questions, comments in the chat box at any time as we go on. We'll deal with as many as possible. I will be moderating, so I will answer questions as we go on if it is germane to the topic. If it is something which I think is really, really going to be beneficial for everyone to hear the answer, I will indicate same to you, and then we will hold off on that question to the end for the Q&A section, at which point Leigh will be answering it live and we'll be having a bit of a discussion. I want to just emphasize respectful discussion, dissent and comments are obviously welcomed. Most of us who are attending, if I look at the list of attendees, are family professionals working in different capacities, and we all have a wealth of information to share. All I want to ask is keep the discussion respectful, avoid hate speech, victimization, or belittling attendees. We're all here to learn. That is the point of these sessions. I do want to ask, please do not record the sessions or distribute the content to persons who did not attend. We do these webinars free of charge. It takes quite a lot of time. I know Leigh spent a lot of time preparing the content for today, and unlawful distribution obviously hurts our ability to feasibly do this again in future, and we do try to do at least 2 webinars a month to build into ourselves and our colleagues and to expand the growing knowledge base in the industry. We will be recording today's session. I will be making the YouTube recording available to everybody usually I try to do it within 1 week, but if things do get a bit hectic at the office, it may take up to, I think, 4 weeks. Alfred was my record with our webinar on mediation agreements. So if you haven't got the recording in 2 weeks, please reach out to me. Please send me racing pigeons, smoke signals, threats of grievous bodily harm, as the case may be, and we will get the recording to you. Please do take down my email address and Leigh's email address. I'm mervyn@vermeulenlaw.co.za. Leigh is lee@vermeulenlaw.co.za, leigh@vermeulenlaw.co.za. Please do reach out to us. We really, really do love connecting with colleagues. We love expanding our knowledge base, and we do that by talking to colleagues in the industry. We all really do have a wealth of information to share. So, what is Think Legal? The second last slide of our housekeeping before we get into the program. It's a legal knowledge sharing initiative by Vermeulen Attorneys, the firm where Leigh and I and a number of other attorneys are based. It works on the premise that a joint knowledge base is really where we need to go as an industry within the family law realm. It has become patently clear to me over the past couple of months that we have such a wealth of information, but that wealth of information is to a large extent held onto in different spheres, in the mental health sphere or the legal sphere or the mediation sphere or even the financial sphere. And it is so important that we all share this information and at the end of the day make the industry stronger. Leigh has just advised me that the generator has now kicked in at the office, so we are a go for launch. So we'll just wait for her to log in, and I'll procrastinate whilst she gets logged in. So what do we do as part of ThinkLegal? We have a WhatsApp group. For those of you who have not yet joined the group, please do let me know. Reach out to me. Please just take note, the WhatsApp group is exclusively to practicing family law professionals. It is at this stage comprised of attorneys, advocates, mediators, psychologists, social workers, all acting in the family law sphere as a matter of course. Unfortunately, because it is a WhatsApp group and it is subject to WhatsApp group limitations, it is not open to candidate attorneys at present. We hope if WhatsApp dispenses with their group limits to put something together for candidate attorneys in due course. If you would like to form part of this knowledge base, please do link up with us. Another aspect that we do from time to time is our ThinkLegal conversations. Leigh and I actually did a conversation in preparation of today's webinar with a few questions and answers, which we will be releasing in a few days' time, which you are welcome to have a look at. Or if you go to vermeulenlaw.co.za, you can see all of this. Then obviously we have our webinars, which is the last thing I would like to touch on, which we do twice a month. You can also visit vermeulenlaw.co.za to see our upcoming free webinars. We have some very exciting webinars coming up in June, which I will tell you about as soon as we have got them confirmed. Our upcoming webinars for May, 6th of May, Kathleen Breert will be presenting top tips to a ship-shape debtors book, where she'll be looking at the best practices of maintaining a healthy debtors book, facilitating debt recovery from clients in an ethical manner without having to struggle to get paid for your extremely important services that you render. That's on 6 May 2022 at 10 o'clock. It's an hour-and-a-half session, and it is free of charge. You can go to vermeulenlaw.co.za to register. Alternatively, pop Leigh or myself a mail, and we will help you to get registered. Then on the 20th of May 2022, hashtag just saying it is my birthday, so I do expect everyone to attend and bring balloons and cake. I'll be looking at civil contempt of court. We've had a plethora of judgments coming from the different divisions on civil contempt of court. Some very, very interesting judgments emanating from the Western Cape, where persons have been admitted for contempt of court and suspended for quite a serious amount of time, as well as in some of the other divisions. We have some very, very interesting judgments on the aspect of civil contempt of court. What is civil contempt? When are you in civil contempt? And what are the potential remedies, ramifications, and defenses? We'll go through that. That is going to be an hour-and-a-half session, which I will be presenting on the 20th of May. So, folks, without further ado, it is my absolute honor and privilege to introduce to you Leigh Govender. She's going to be running through the presentation today, and I specifically asked Leigh to do this presentation because what I have found as an attorney in active practice is we very often spend so much time conceptually discussing court cases emanating from the superior courts, where they deal with parental responsibilities and rights and aspects surrounding matters which are often dealt with in the children's court, that I personally will confess to becoming to an extent out of touch on what is happening at grassroots level in the children's court. This presentation today, I've specifically asked Leigh because she is in children's court at least 2 to 3 times a week, and she is seeing what is happening in reality on the ground. So for the legal practitioners amongst us, a lot of what you may hear or see today may be stuff that you do deal with. Please do bear with us. It is Children's Court 101 and not 404. But I've gone through the slides that Leigh has prepared for us. There are huge nuggets of wisdom in there. By way of final introduction, Leigh is a practicing attorney at Vermeulen Attorney. She specializes in children's matters and specifically the children's court. I was very honored and privileged to have had Leigh as my candidate attorney a number of years ago. And I was even more honored and privileged to have her decide to be retained by the firm, and she is now heading up our children's court matters, or our magistrates court children's litigation. I know that Leigh is extremely passionate about this topic, and I know that she's got a wealth of information to share with us. So Leigh, without further ado, I'm glad to see you're back online. The generator is working as it should. Let's hope it continues working as it should. And I'll hand over to you. Thank you very much.
Thank you so much for the opportunity, Mervyn, and I just want to welcome everyone that has joined the session. Thank you so much for registering. I truly hope that the session today is really going to give you some knowledge. As Mervyn indicated earlier, we are taking some questions. So if you guys do have any questions as I present the content, please do add it in the chat box. And we'll either attend to it at the end of the session, or Mervyn will answer it as we go. So yes, once again, thank you so much for joining. I hope that you're going to learn a lot today. I most certainly learned a lot preparing the content. So welcome and thank you for your time. In respect of the first question that we're going to deal with, so it is Children's Court 101. So we're really focusing on what happens at Children's Court. Some of the questions that came through weren't necessarily related, but I'll try and answer them to the best of my ability. So delving right into it, what is Children's Court? Now, there was a question that came through, dealing with, is Children's Court equivalent to a superior court? Is it the equivalent of a high court? Simply put, in terms of Section 42 of the Children's Act, right? It does state, particularly Section 42(1) of the Children's Act, it does mention that every magistrate's court is a children's court. So you'll see in every area there is a magistrate's court. Within that magistrate's court building, our children's court sits. They do have the equivalent of a district level magistrate's court. So generally, in your district level courts, you would find it's family court, which is broken up into children's court, domestic violence court, maintenance court, and so forth. So children's court is the equivalent of a magistrate's court, and every magistrate's court in every area generally has a children's court that sits within it. Now, if we go to the next slide about where children's courts are based. So every area has a magistrate court, as I've mentioned, and in every magistrate's court, you will find a children's court. So in Roodepoort, we've got Roodepoort Magistrate's Court, and in Roodepoort Magistrate's Court, ground floor next to the cafeteria, we've got our children's court sitting there. So in every area, there should be a children's court. But if you aren't too sure, you can reach out and I can just check jurisdiction for you and let you know where that court is based. Next question, who can approach Children's Court for relief? Now, if we look at what the Children's Act says, particularly Section 53, okay, it particularly tells us that the Children's Court has the powers to adjudicate upon matters, and persons can refer to Children's Court or matters to Children's Court. So it's generally children themselves who are affected by any circumstances that require adjudication. So a child can refer a matter to Children's Court themselves, anyone acting in the interest of a child. So this can be an auntie, an uncle, a teacher. We've seen that often where teachers refer matters to Children's Court on behalf of a child. Then we've also got any other person who's acting on behalf of a child who cannot necessarily act in their own name. So this is generally in instances where children are very young, 2, 3, 4, 5 years old, somewhere there. And then anyone acting as a member of or in the interest of a group of a class of children. So, we do see organizations who are approaching Children's Court on behalf of a class of children. It could be dealing with issues of abandonment. It could be dealing with issues of children who are maybe in a youth care center. So it's generally children, to wrap it up, it's children, it's parents, it's aunties, it's uncles, it's teachers, social workers, police officers. Anyone generally acting in the interest of a child has the power to approach a Children's Court for relief. Then, if we look at the next question, okay, and this is quite a big one because I don't think people really take children's court seriously. So we do find people who, when they are served with papers to appear in children's court, they don't take it seriously because it's not necessarily a high court. But I've got a very big surprise for you this morning. And that's related to the question itself. Can I be subpoenaed to appear in children's court? Now, you can definitely, same with a high court, be subpoenaed to appear in children's court. So if I can explain the process to you, practically speaking, if you refer a matter to children's court on a Form 2, and don't panic too much if you don't know what a Form 2 is at this point, I'll get into that a little bit later. When you submit a Form 2 to children's court, the magistrate will consider it, and if they then feel that they want to order a court date for the matter to be investigated and the parties to appear, they will then issue what we call a Form 4. Now, essentially, the Form 4 is something that you serve on the respondent, and that informs them that they need to appear in children's court on a particular date and at a particular time. So, in terms of Section 57 of the Children's Act, we know that it says that the clerk of the children's court, so this is the person really dealing with the admin of children's court, can issue a written notice to request a party to appear before children's court, okay, to attend such proceedings. So if you fail to appear at children's court for a court date, and I've had it before, you can request or inform the magistrate that, listen, the respondent hasn't appeared today for their hearing. Can you please issue a subpoena that we can then serve on them? So it does happen. And please do take it very seriously. If you're ordered to appear at children's court, I seriously encourage you to take the invitation seriously and to make yourself available for the hearing. Then a very interesting question that we don't necessarily deal with often, but it is something that a lot of people wonder. Will myself and my child be expected to give evidence at children's court? Now, the reason this is a big one is because, you know, it's daunting for an adult to have to give evidence in court. Now, imagine how much more daunting it is for a child to have to present evidence in court. You know, it's not something we necessarily want to put our children through, but unfortunately, some matters do require it so that we can reach a conclusion. Now, people who can generally, or the Children's Act provides for a list of people who are able to give evidence at children's court, and this is one, a child who's involved in the proceedings. So we know this is something we don't necessarily want, but it sometimes happens, and it's sometimes something that we need to deal with. So it's a child, a parent, any person who is a holder of parental responsibilities and rights, a caregiver of a child, so maybe an auntie, an uncle, someone like that, and then a person whose rights may be affected by an order that the children's court may make. So this could even be the dad. If children's court is going to order something that will really affect his rights as the father, then obviously he will have to produce evidence so that we can reach a conclusion. Then the court can also order people who have a sufficient interest in the matter to produce evidence. So this could be grandparents, you know, if the matter is very convoluted, it could be grandparents, it could be aunties, it could be uncles, it could be social workers. We've seen a lot of social workers testify in children's court. However, most of them, the way that they produce their evidence is by way of the reports that they furnish to the court. But it does happen where social workers are required to adduce evidence at court. Now, also a very, very interesting question coming up next is, how do the proceedings work in children's court? Now, I don't think we really have a straight answer as to how that works because every matter is different. But what we do know from the Children's Act, particularly Section 60, of the Children's Act, it says that the presiding officer, so in layman terms, for those of you who don't know, that is the magistrate, the person who generally wears the robe with some red happening here. That's the magistrate, and the magistrate is the person who conducts the proceedings. So they will head the proceedings, and what will happen is they will, depending obviously on the nature of the matter before them, they will call people to produce evidence in children's court. Alternatively, they may question the person. So if you're the applicant, They may ask you some questions as to why you referred the matter to Children's Court. What do you require our assistance with? How can the court be of help? Alternatively, they may cross-examine some people, and I've seen this happen before, where the magistrate cross-examines the respondent based on an answer that he's maybe given. So to sum it up for you as to how Children's Court proceedings work, so there's no straight answer as I've indicated. Generally, what will happen on your first appearance, the magistrate will indicate, why are we before court? What are the issues in dispute? What is the relief that you're seeking? Then the magistrate may question some people, may cross-examine some people that are involved in the proceedings. It could even be social workers. And then kind of the proceedings just run like that. It's kind of taken from an appearance to an appearance. So there's no set answers as to how the proceedings work, but you know the basis of what can happen. People can be questioned, people can be cross-examined, and the magistrate may also call someone to give some evidence that they're required to be heard in court. Then, next question goes, who are the important role players in Children's Court? Now, in Children's Court, when you attend Children's Court, it's very overwhelming for the first time. You're seeing magistrates, you're seeing people with a lot of files. Those are generally the attorneys. You may see some advocates there. You may see some social workers. Sometimes you can't really disguise them because they dress like any other normal person. But the general important role players that we do see in Children's Court is the magistrate. So this is the presiding officer. So every magistrate's court has a Children's Court, and in that Children's Court, they have a designated magistrate who attends to matters in the Children's Court. Okay, so we know in Roodepoort we had a magistrate, I think it was back in 2020. Unfortunately, he passed away from COVID. We now have Magistrate Davies who took over. So we've got the presiding officer who's the magistrate. Okay, they are the one who control the proceedings and conduct the proceedings in their court. We then have the attorneys. So this is where people have appointed legal representation. We then have social workers. They play a vitally important role in Children's Court proceedings, and you know, I really take my hat off to social workers. They do so much big work and for very little pay, but we really do appreciate them. So if there's any social workers in the session, we are very grateful for the work that you do. And then there's obviously the children. You may from time to time when you're at Children's Court see some children running around. It's not really the ideal place for kids to be, but they obviously are part of the proceedings and they are sometimes required to attend court. So those are really the role players and the people that you're going to see wandering around at court. Those are the most important people that we see. From time to time, you may also see police officers, but that's not really something we see on an everyday occasion when we attend Children's Court. Now, next question. What are the main issues that Children's Court deal with? Okay, so obviously you'll see from the pictures that I've put there, the key pictures I found. Some of the issues that we deal with at Children's Court is things such as the protection and well-being of a child, right? So child protection. Then it's also the care and contact with the child. That is something I deal with very frequently in Children's Court. One parent not having contact or one parent having care and not wanting to give contact. That's a very common issue that we deal with in Children's Court. And it's the paternity of a child. I haven't necessarily dealt with the matter where the paternity was in dispute, but we do deal with issues of paternity of a child. And generally what happens there, you know, you do some DNA tests, figure out who's the father, who's the mother, etc., find a way forward and a solution. Sometimes what we also deal with is early childhood development services. Also haven't really dealt with anything to that effect, but these are your ECD centers, you know, that also bring matters to Children's Court. Then, you know, something that's very dear to the heart and something I've dealt with on many occasions in Children's Court is the maltreatment and abuse and neglect of children. That is obviously very big. They're very sensitive matters. Take a lot out of you emotionally, but you know, you do what you can to get the best outcome, not for the parents, but for the child. Then something interesting that Children's Court also deals with that some of you may not know is the adoption of a child. So sometimes inter-country adoption. And, any other matter, relating to the protection and well-being of a child. So there's several aspects that the Children's Court can deal with, but the list is quite coherent in being listed in Section 45 of the Children's Act. Then, if we can look at, and this was a question that came through from someone that had registered for the webinar, are children's court equal to high courts? Okay, so children's courts are definitely do not have the same status as a high court. As I've mentioned, children's courts is the equivalent of a district. Within the magistrates court, we've got regional courts and we've got district court. Children's court fall under the aspect of district court, so they don't have the status of a high court, and they most certainly don't have the status of a superior court or a Supreme Court of Appeal, whatever you want to call it. So status of a children's court is district magistrates court. It's kind of the lowest court within the range of courts that we do have in our country. Now, if we can then look at approaching children's court for relief. So this is a very common question that I get. People will say to me, this is the issue that I have. Does it render me approaching the children's court for relief? Now, Section 44 of the Children's Act is very clear in, the list of things that you can approach children's court for relief. If we look at, the things that you can approach children's court for relief, like I mentioned, those are the list of things relating to the care and contact of a child, the well-being of a child, the protection of a child, adoption, etc. But the most important question that I also get is, can I approach any children's court for relief? So someone will come to me and they'll say, I've got this issue. Can I approach children's court for relief? And we'll say yes or no. We'll determine whether or not children's court has jurisdiction to adjudicate upon it. Then the next question will be, well, can I approach any children's court for relief? I'll be in Durban this week. Do you think I could just pop in at the magistrates court in Durban and approach that children's court for relief? It's very clear in the Children's Act to say that the jurisdiction, of a children's court is where the children are based. Okay, so if you stay in Ridderpoort, and I've had it before, I've had a matter where mom was based in Ridderpoort, dad stayed in Kimberley, and the children stayed with dad in Kimberley. The big question there is which children's court had jurisdiction to adjudicate upon that matter. And in that matter, the children's court that had jurisdiction to adjudicate on the matter is the children's courts in Kimberley. Why, you may ask? That is because that is where the children are based. So if we look at Section 44 of the Children's Act, it says that the court of area in which the child involved in the matter is originally resident is the court that will have jurisdiction. So if the kids reside in Durban, you'll go to the Durban Magistrates Court, depending on the area. If the kids stay in Sandton, you'll probably approach the Randburg Magistrates Court, Children's Court for jurisdiction. But the other thing that's also important to take note of, Section 44, subsection 2 of the Children's Act says that where it's unclear which court has jurisdiction in a particular matter. So sometimes it happens, where we don't really know which court to approach. It says that the children's court before which the child is brought, is the court that will have jurisdiction. Now, I haven't dealt with the matter like that before, but at least if you're struggling to determine which court has jurisdiction because the matter is convoluted or it's complicated, just know that whichever court you take the child to is the court that is going to have jurisdiction in that matter. I just quickly want to see if my slides have disappeared. If you guys bear with me for 1 second, let's just quickly see here.
I think someone else has shared their screen, I'm afraid.
I think so, Myth. I'm like, where did my slides go? I have no idea. Sorry, I'm just trying to check what's happening there.
Okay, I think they've stopped sharing now, so thank you for that, whomever hijacked us. I'll quickly load the PowerPoint again for you, Leigh, and then you can just take control again from me. Terry, no problem. We'll send you the bill in the mail. Don't worry.
I literally was like, did a demon take over my laptop? What just happened?
I've heard of load shedding, but like, yo, this is now hectic. Okay, let's go
I've got it.
to, I think we're over there. There we go.
Yeah, I'm back. So I was going to get to the slide I was at. Okay, there we go. Perfect. Alrighty, apologies about that, guys. I don't know what happened, but that's fine. All right, let's quickly move to the next slide. Now, this is quite a big one. Children's Court has a lot of forms which need to be completed, and sometimes it's overwhelming. When you are referring a matter for the first time to Children's Court, the clerk's like, okay, which form would you like to fill out? What is your issue? And you just stand there and you're like, I have no idea. Could you maybe tell me what form I need to complete? Now, is there any form I need to complete when referring a matter to Children's Court? So you'll see there on the slide, I've actually put a screenshot of the form that we usually complete when we refer a matter to Children's Court. It is the famous Form 2 that gets completed. And with that form, I'll go through what must get attached. There's some documentation that needs to be attached to that form. Now, where you can get this form from, so you can either look on the Justice website, you can download the form from there. But what I generally like to do, because we can't always trust if the Justice website is updated, is to actually go to your nearest Children's Court and request a copy of the Form 2. Then you know it's an updated version of the Form 2 and you can complete that one. So if ever you need to refer a matter to Children's Court, be it for an investigation, be it for a parenting plan to be signed, or parenting plan to be drafted, this is the famous form that you complete. There are also other forms if you go onto the Justice website, right? I'm not going to bore you too much with that admin, but if you go onto the Justice website, you can just say Children's Court forms. You can type it onto Google. You'll see there's a whole bunch of other forms that we can also complete. Not all the forms can be found on the Justice website, though. A lot of them, you've got to physically go into court, to get those forms. Those are like your Form 1, Form 3, Form 4, Form 5, 6, 7, 8, etc., etc. But some of the forms, if I can just give you an indication that you can find on the Justice website related to Children's Court, is your Form 2, as I've indicated, it's your Form 7, which deals with the medical report and age assessment of the child. Then there's your Form 10, that is for the return of a child who's wrongfully removed or retained in terms of the Hague Convention. Then we've got your Form 11, which is when you're applying for access to a child who's been wrongfully removed or retained. So you'll see if you go onto the Justice website, there's a whole bunch of forms there that you can complete if you want to go to Children's Court. But the main one that I make use of when referring a matter to Children's Court is the Form 2. And I'll explain to you a bit later what are some of the documents that you'll need to attach to this Form 2. It's not as simple as you complete this form, you go to Children's Court, you hand it in. Unfortunately, it's not that simple. The admin of it is a bit more in-depth. Alrighty, now this is a big one, and I think a lot of people would say when attorneys say you can't represent yourself, they're trying to make more money, but that's not the truth. We are saying that with very good reason, and I'll explain that to you shortly. Now, the question is, can I represent myself at Children's Court? Okay. Like with any other court in district court, domestic violence court, maintenance, Children's Court, you can 110% represent yourself. You don't need an attorney to go to these courts or to, run proceedings in this court. However, I must stress the fact that the reason you need to, or you should rather get an attorney to assist you in these courts is because, and this is not to boast at all, but we understand the law better. We know what is the relief that you can ask. We know what are the loopholes that you can try and jump through. We understand the processes and the systems of this court. I've had many clients who would say they'd consult for the first time. They'll say, no problem, I'll go and represent myself. 2 weeks down the line, they give me a call. Could you actually assist me? It's very overwhelming. I don't know what's happening. I don't understand the process. You'll see even in that picture, it says the person is saying, what do I say? You don't know if you're going to be saying something that incriminates you. or something that could jeopardize your case. So you can definitely represent yourself in children's court, but I would rather suggest, and I would highly advise, that you get an attorney to rather represent you. I've already explained, we understand the process better. We know what the law says. We know the loopholes that can be jumped. So it really puts you at ease and puts your attorney in the driving seat. So Section 54 actually of the Children's Act also says that a person in a matter before children's court can represent themselves, but they can also appoint an attorney, which is obviously going to be at your own cost. The court's not going to offer to pay for that attorney's services, so please be aware of that. But yeah, you can represent yourself, but again, I wouldn't advise it. And when you go to children's court yourself, you'll probably call back and tell me, Leigh, you were right. Can you please assist me? And I'll be standing there ready to help you and ready to roll. Okay. Then, all right, questions and answers. So before we move on to more content and before I make you guys tired, some of you look like you need coffee, but that's okay. I'm just going to run through some questions and answers, and the way that we're going to conduct it is to focus on the questions that were given when people registered. So I had quite a few questions that came through on the registration link. Now, some of the questions that I just want to focus on, there's a lot of them will still be covered in the content to come, so I don't really want to get into them now. But if we can focus on one which I thought was really interesting and which I think a lot of you may have yourself, is this person says, is it possible to visit children's court to observe what happens? If so, who do you organize it with and how does it work? Now, what you must bear in mind about children's court, maintenance court, domestic violence court, they are in-camera proceedings. What does this mean? This means that these proceedings are closed to the public. You can't just go and sit in children's court and listen to people's drama and the matters that are happening. It's a very private, courtroom with private proceedings that happen for obvious reasons. So you can't just go and sit in children's court and listen to other matters. They don't even allow grandparents and grannies and grandfathers to sit in unless the magistrate understands why they are there and unless they have an interest in the matter. So I think, to answer your question, if you want to observe children's court proceedings, it may be wise to speak to the magistrate who sits in that children's court, tell them that you'd like to learn a bit more about children's court and get their permission to sit in on the proceedings. I don't know whether they'd be willing to give you that permission, but it's worth a try. But you can't just go and sit in randomly like criminal court. Criminal court's quite open. You can sit in, the public can sit in and listen, no problems. Children's court is very private, very confidential, obviously, to protect the children and the identities of the families themselves. Then the other matter, or the other question that we got, is what happens to children that are removed from their parents? Now, it really depends on the reasons as to why the kids have been removed. I'll tell you a story. It's quite a sad one. In Randburg, I was running a children's court matter there, and we were sitting waiting for our matter to be heard. And the police and some social workers came in with this little girl, very, very young, no shoes, clothes are dirty, hair's a mess. She had like one scruffy teddy with her. So the police were coming in with this child, and we went to inquire from the clerk as to, why this child is here, because there were obviously no parents. It was just the police and the social workers. And they'd essentially brought this kid to the clerk of the court so that the magistrate can see whether or not this child is in need of care and protection. And, by the end of the day, the child was then taken to foster care, to be looked after. She was put into the state's care until her matter was obviously heard in children's court and until the magistrate could make an alternative order, to put this child in a place of safety, maybe with other family members. So if we look at this question, what happens to children that are removed from their parents? To answer your question quite simply, they are placed in alternative care. Now, again, this could be in the care of other family members such as aunties and uncles. But most times, and this is the sad reality of the country, is they go into the state's care, they go into the system, they go into youth care centers, they go into children's homes. And that is where they stay until their matters are heard at court, or until other family members come forward and are willing to take care of the child. So yeah, when kids are removed from their parents because of neglect or abuse or maltreatment, they generally just go into a place of safety, temporary safe care. But most times it's just firstly to the state's care and then maybe into an alternative family member's care. Now, the other question that I got, so we got quite a few. Like I say, some are already going to be dealt with in the content to come, or have already been covered in the content we've already run through. But the other question that I got was, what happens if a court order is not upheld in respect of a child's matter? Now, it really depends. When I looked at this question, it depends on which court made the order. So if it's a children's court that made an order, I would refer the matter back to children's court for enforcement and investigation. If it's a high court, obviously, if it's a high court order relating to children, then, you know, we've got the whole contempt of court proceedings that you can run. So to answer that, simply, it depends on which court made the order. Children's court, you refer it back for investigation and enforcement. If it's a high court, you can obviously run with the contempt of court proceedings. So those are some of the questions that we did receive. The others I think I'll deal with at the end. But a lot of them are probably going to be covered in the contents already. So I don't want to answer them now, and then I have to regurgitate the content at a later stage. So Merv, I'm going to move on to the next set of content. And then if you can just monitor the questions for me, and we can get those at the end.
Sure. Leigh, can I just jump in for a second? I posed the question earlier, would any of the attendees like you to go through one or two of the standard forms? I see Ronelle has put herself out there. Thanks, Ronelle. Yes, Esther, she says, yes, please. Can I just ask any of the other attendees, would anyone else like Leigh to just go through for example, the Form 2? I think that's the most important one. You know, we don't have to go through absolutely everything, but maybe just show them what a Form 2 looks like. And yeah, okay, so we're getting quite a few yeses. So can I ask you, Leigh, would you mind just budgeting like 10 minutes at the end? And then I also have a nice family advocate report with all of the parties' names and details redacted, which we can also share with everyone if there's time at the end. I don't want to put you too much on the spot.
No, it's fine. I'll definitely go through the Form 2 and how to complete it. The first time I saw Form 2, I'm like, I have no idea what to put here. But as time goes and the more experience you get, the easier it becomes. So I'll definitely run through a Form 2 with you guys at the end. Show you how to complete it, show you which portions are very important. And as I said, I'll also explain to you what are some of the attachments that need to go with the Form 2 when you submit it. So I'm more than happy to do that. And if you guys require a link to the Form 2, please let me know, Mervyn, and I will then email it to you. I don't have any problems in that regard. Alrighty, guys, moving right along. This one is quite big. It's also a question I get quite frequently because people don't understand, you know, if children represent themselves, do they get attorneys? If so, must I pay for the child's attorney? Where's this attorney going to come from, etc., etc. So the question is, do I represent my child at children's court, or do they represent themselves? Now, Section 54 of the Act says that where a child is involved in a matter before children's court, okay, is not represented by a legal representative, so maybe a private attorney, and the court's of the opinion that it would be in the best interest of the child that they have legal representation, the court must refer the matter to legal aid for legal aid to get an attorney to speak on behalf of the child. Now, I've had a matter previously in Ridderpoort. I represented Mom. And Mom obviously approached children's court to get more contact with the children because the children were residing with Dad. And the magistrate then ordered that legal aid be appointed for the child because essentially you want to hear what the child's opinion is or what the child's view is regarding the matter. You know, they often say in South Africa, kids have a voice, not a choice. That's fine, but we need to hear what their voice is. We need to hear what their opinion is, okay? So it does happen often where legal aid gets appointed to represent children in children's court matters. Now, it's not as formal as a private attorney. So they don't say, okay, child, I'm scheduling a consultation with you. Come through to my offices. Let's discuss the matter. They'll very informally discuss the matter with the child at court, maybe call the child outside into a separate room, ask the child, what are your thoughts regarding the application that daddy has brought? Who do you want to stay with? How do you feel about staying by mom? How is it working? Do you see daddy often? Do you see mommy often? So it's a very informal representation, but legal aid, once having spoken to the child, then informs the magistrate of what the child has said, and that obviously then gets taken into consideration in the proceedings. So either the child can be represented by a private attorney, which is not really, I don't find that often, or they can just be represented by legal aid. And I think the other important question that you guys are probably wondering is, who then pays for legal aid? Like, must the parents now pay this attorney to, represent the child? Not at all. Legal aid is paid by the state, so you won't have to pay any costs if legal aid represents your child. You don't have to stress about it. And the other cool thing or comforting thing, that I find with attorneys from legal aid that represent children is they're not as harsh and as staunch as private attorneys. They know how to deal with children. They're very calm, very collected. So they put the children at ease, especially when consulting with them about what their view is. So it's nothing formal, quite an informal appointment, but a very important one. We need to remember that. Alrighty, then, will my child be expected to talk in court during the proceedings? Now, Section 61 of the Children's Act, okay, it empowers a presiding officer. For those of you who don't know, that is the magistrate who conducts and controls the proceedings, to allow a child, so it gives the magistrate the power to allow a child to express their views, and to also cross-examine on their views in respect of the matter. Now, I've had it before where a magistrate has asked a child directly in court, are you comfortable still staying by daddy? Do you want to stay by mom? But what I also find in a lot of matters is children don't want to necessarily answer on the spot, or they don't want to answer in that room because mom and dad are there. They want to make both parents happy. So I've had it previously where the magistrates actually request to speak to the children privately in their chambers. And that is how they then get answers out of the children. But it can be that your child will be expected to talk in children's court. Probably not going to say too much because we are cognizant of the fact that it's daunting for children, and they also don't want to express their opinion when both their parents are in the room because they don't want to make either of them unhappy. So it can happen, but generally magistrates would prefer to speak to the children in chambers and to then take their views into consideration. Now, what should I expect for my first appearance at children's court? And I think this is the portion that's going to make a lot of people unhappy. But unfortunately, we do stay in a country that's inundated with matters. Our justice system, is trying to, how can we put this? It's just trying to match other countries, and we're trying to do what we can with the resources that we have. Now, first appearance at children's court. I always tell my clients when we're going to court for the first time, please come with a lot of patience. Please come with a lot of understanding. Maybe bring some snacks along so that you can keep yourself sustained while you're waiting for your matter to be called. But generally, what to expect for your first appearance, okay? When you get to court, I would say the night before, right, to calm yourself and calm your stress levels, calm your anxiety, is make sure you know where the children's court is. So maybe visit the court before that, inquire from the security where exactly the court is. So on the morning of your first appearance, you know exactly where you're going, you know exactly who you're speaking to. So when you arrive at children's court, I would advise you firstly to speak to the clerk of the court. Tell them, I am here, I'm present today. Please don't forget when you call my matter, I'm just sitting around the corner. Find out what matter or what number your matter is on the roll. That also helps you to understand when you'll be called. Although they don't always go according to the court roll, it just gives you a brief indication of how busy children's court is on the day. And then you're going to sit and wait. You can expect to wait long hours for your matter to be called, particularly if the court's inundated with matters on that day. And what else you can expect is you're either going to wait long or you're going to get called quickly and your matter's going to be stood down until a bit later in the afternoon. So that's what you can expect on your first appearance, is a lot of waiting and your matter to probably be postponed to another appearance. Most children's court matters are not finalized on the first occasion. So just know you're probably coming back to court. So make sure you've got some leave days and you're going to speak to your boss about having to put in another leave day for maybe 3 months down the line. So hopefully that answers your question on some expectations for your first appearance. It is daunting, but please just understand, children's court, they're really trying to do what they can. It's one magistrate dealing with all the matters, so you may wait some time, but that's okay. I think just be patient, and yeah, maybe in that time you can prepare for your appearance and read through your paperwork and make sure you've got your story straight. Rightio. Then next question, what time is best to arrive at children's court for my appearance? Okay, I've had clients that have arrived at like 10 o'clock. Court starts at 9 o'clock, but they always say you must be there at about 8:30. So please don't be those clients that arrive there at like 10 o'clock and your attorney's been waiting there since 8:15 because we're punctual people. So the best time to arrive at children's court is 8:30. The form 4, which will get served on you, will also indicate you need to be at court at 8:30. Be at court at 8:30. It gives the clerk time to call your matter. If your matter is not on the roll, it gives the clerk some time to find the file. So be at court at 8:30. Court usually starts at 9. So just make sure you're on time. And if you're late, be aware that it has consequences, and please don't put your attorneys in the position where they need to be explaining to the magistrate where you are. So please arrive on time. It's very important. Okay, next question. And I think this is an exciting one because I've been to several children's courts. I've gone to Klerksdorp, I've been to Kimberley, I've been to Roodepoort, I've been to Randburg, I've been to Boksburg, Germiston, all around. And can I tell you something? No children's court looks the same. I've been to one where it looks like a boardroom with a round table. You don't wear your robe. So Roodepoort, for example, you're not allowed to wear your robe in the children's court itself because it's obviously a very daunting persona that you give off, and because the kids are there, you don't want to give them that persona. But I've been to, like Klerksdorp, where it's formally in a court, where you do robe. Randburg robes, it's in a court. Let me think. Kimberley was in like a boardroom. Also didn't necessarily wear our robes. So it depends. Some children's court look like boardrooms with cute little pictures on the wall. Germiston's got some paintings on the wall for the kids to look at. And yeah, some of them look like very formal courts that are quite daunting, but most of them are like round tables with microphones. Don't wear your robe. Kids can sit next to you. There's some toys for the kids to play with. So it's quite informal, and it just makes the process less daunting for the kids and maybe for the parents themselves. So if you guys do see children's courts that are very pretty and they have nice paintings, take pictures of it and let me know so that I can get my matters there. But generally children's courts, yeah, it depends on the court itself. Boardroom, sometimes the court itself, it depends. Okay, next question. Am I expected to bring my child along to children's court? Now, I'll tell you this, for the first appearance, it's not normally required, and please don't say that it's not always required. It's not normally required that you bring the children along to children's courts, okay? So the reason is, for the first appearance, we're still determining the lay of the land. What are the issues? Do we need to talk to the children? Is it necessary for the kids to be here? So first appearance, it's not always necessary that the kids be present at court. But the magistrate will indicate, or the clerk of the court will indicate when they want the children to come to court, and you need to make sure on that day that you communicate with the school and the school understands that the kids need to attend court. But please, if the kids are not required to be there, I urge you as parents to not bring them along. It's not a fun place for children to be. It's very traumatic. The courts are not welcoming places at all. So please don't bring them along and make them sit there and make them be tired from waiting the whole day. Maybe leave them in the care of another family member. But if they do need to be there, you know, maybe bring some snacks along. Make sure they're warm dressed if it's winter because the courts are freezing. And I don't know, maybe bring a tablet along so that they can keep themselves entertained. Because it's really a long wait and you're going to be very frustrated. So just, yeah, if it's necessary, bring them along. If not, please rather leave them at home so that they can enjoy themselves and not be involved in these proceedings between mom and dad. Okay, next question. Can I lodge a new application at Children's Court any day of the week? Now, this is really dependent on the court, okay? From what I've seen, Roodepoort, if I'm not mistaken, and if there's anyone that litigates out of Roodepoort, please just check it, pop it on the chat box if I'm right or wrong. But Roodepoort, I think you can only lodge a new application on a Monday and a Wednesday, or it's a Wednesday and a Friday, or a Monday and a Friday. But one of those days are the only days that they accept new applications. So you can't just go there any day of the week with an application like a Form 2. You've got to go on certain days. And that's just because they need the rest of the days to catch up on actually getting those applications to the magistrates for decisions. They don't want there to be a backlog, and they don't want you to wait a long time for an outcome. So Roodepoort, there's certain days of the week I know that you can submit a new application. Now I'm particularly talking about the Form 2. I don't know about the other forms that I've mentioned. I'm really not sure about those. You're going to have to inquire. But Randburg, for example, from what I know, you can submit any day of the week, obviously except for weekends. So if you want to lodge a new application at Children's Court, just go and inquire and make sure that it's not a specific day of the week that you're allowed to come. And if it's a specific day of the week that you actually go on those days, because if you don't, the clerks are not going to help you. I can almost guarantee you that one. Alrighty. Next question. What orders does the Children's Court have the power to make? Now, this is quite an interesting one, right? Because Children's Court doesn't have the status of a high court, but it can make some compelling orders in respect of matters involving children. Now, if you look quickly, if we have a look at Section 46 of the Children's Act, okay? This is the section of the Children's Act that sets out specifically what orders the Children's Court has the power to make. Now, if I can read through the list for you, or I'll sum it up for you. The one is an alternative care order. So this is placing kids in alternative care if the care that they're currently in is not in their best interest. So this is temporary safe care, maybe in the care of uncles and aunties, etc. Then it's an order placing the child in a child-headed household. Now, you know, in South Africa, the reality is there are many households that are headed by children. And I'm not going to delve into the reasons for that, but we know that that's the reality. So the court does have the power to order that a child in a child-headed household be placed in the care of adult supervision, because children can't necessarily run homes by themselves. Then they can also make adoption orders. So this is an interesting one. I haven't ever run, you know, an adoption order or an adoption application out of Children's Court, but they do have the power to adjudicate upon adoptions. They can also make a partial care order, you know, where they instruct the parents or caregiver of a child to make arrangements with a partial care facility to take care of the child during specific hours of the day or night. Okay, then they can also make a supervision order, placing, you know, the child or the parents or caregiver of a child, or both the child and the parents and the caregiver under the supervision of a social worker. So that is one that I've seen previously happen, and it's quite a hectic order, if I can put it like that. And the other order that they can make is a child protection order. And I've seen one like this before. It's a very dangerous order where they order that the child be released from someone's care into the care of someone else because of allegations of abuse, neglect, maltreatments, etc. It's a very dangerous order to get. And I'll delve into it a bit later. We got a question actually about where kids are placed in temporary safe care and removed out of the care of their parents. Can that be done without a court order or with a court order? So I'll delve into that a bit later and give you guys some context in that regard. Now, let's quickly see. Next question. Can the Children's Court order that my matter be referred for settlement? It definitely can. And I think this is a really good piece of law that allows for Children's Court matters to be referred for settlement. We know Children's Court matters that are particularly acrimonious, that run for long periods of time. It really does so much damage to the families involved, most importantly to the kids. So it does happen that Children's Court or the magistrate of a Children's Court can refer your matter for settlement. But what I find very interesting when I was going through the content and I was doing my research on this one, it says before a court or before a magistrate just orders that a matter be referred for settlement, they will consider, or they must consider, several factors like the vulnerability of a child. We know some matters are not capable of settlement. There's the big question, it's not related to this, but can domestic violence matters, for example, be referred for settlement and mediation? We know all matters cannot be mediated. They shouldn't be mediated, especially when there are allegations of hectic abuse, serious maltreatment, serious abuse. So those matters need to be investigated. We can't just sweep things under the carpet and say, good, we're now a happy family, let's move on. But the Children's Court will first look at the vulnerability of a child. So what is happening in that matter? Is there abuse? Are there sexual allegations of abuse, etc., etc.? They'll also then look at the ability of the child to participate in the proceedings. Remember, kids play a vitally important role in proceedings in Children's Court. It's not only the parents that run the proceedings. The kids have a voice. The court doesn't necessarily make the order according to what the kids' views are, but their views are taken into consideration. The other factors that the court's also going to look at is the power relationships between the family. And I think this is a crucial one. Some families, we know some people have pull and power in respect of proceedings, maybe because of money, because of, attitude, whatever the case is. So the court's also going to look at that and see, can these two parties actually sit in a room and can they discuss settlement? Now, the other thing that the courts are going to look at is the nature of the allegations made by the parties in the matter. And that's what I was explaining to you earlier. If there's allegations of a sexual nature, it wouldn't make sense to refer the matter for settlement. Those allegations, before we can even discuss settlement or discuss a solution or a way forward, those allegations need to be investigated. So I think that's important. Not all matters should be, let me not say can be, let me say should be referred for settlement. Allegations need to be investigated. They need to be investigated properly so that the correct order can be made in the best interest of a child. Then let's quickly look. This is actually our last question. So we're running good for time. So I think we'll be able to get through most of the questions that you guys have posed. So I'm very excited for that. But the last question, and this is also a question that came through on the registration portal, is, am I able to appeal a Children's Court order? Now, this is a very interesting one because Children's Court is obviously a district court. It's one of the lower courts in the hierarchy. But Section 51 of the Act actually states that you can appeal an order made in Children's Court. Where would you take the appeal to? You would take it to High Court. So if a magistrate makes an order that just really doesn't make sense to you, it's nonsensical, it's not in the best interest of the child, you can definitely appeal that order to High Court. So if you're sitting with a matter, you're not happy with the judgment, and I've had it before where I was entirely not happy with the judgment that a magistrate made. If your client is happy, you can then take that order on appeal to the High Court that has jurisdiction. So that wraps up the questions, everybody. I hope that that was helpful. Merv, if we can just run through some of the questions now that we have in the chat box. I saw questions coming through, but I can't really see them now. So if you can just take me through those, and then we can do a good engagement session, hopefully for the next 45 minutes or so.
Excellent. Okay, let's start with the last one to come through. And okay, I'm just Leigh, can you just mute yourself? I can hear my voice coming back, and I'm not nearly as eager as any of our participants to hear my own voice. I'm going to start first off with the last question that came through, a very, very good question. And it's actually one that I'm dealing with now in a care and contact dispute that I'm busy with. What happens when a protection order is in place? How is this dealt with if there is a 100-meter contact perimeter between parties? Okay, just one thing in terms of domestic violence. There are certain types of relief that our domestic violence courts can give, but it is they don't generally have a geographic distance. It's more in terms of acts that you can't do. Don't commit an act of domestic violence. You can't enter a shared residence, for example. So there it would be relevant. But Leigh, you've obviously had quite a few matters where there has been domestic violence either between the parties, and I think, unfortunately, one or two cases where the kids were involved as well. Do you want to maybe give us a bit of insight how the court dealt with that?
Sure, Merv. So let me say this from the outset. Whenever we deal with matters involving children and there's protection orders in place, mom got a protection order against dad, dad ran to court, got a protection order against mom. The first thing I say to the parties, and I'll tell you how the courts navigate it, but from my point of view, okay, if you need to co-parent, you need to ask your clients, does it make sense for you to have a protection order in place that's really going to affect the co-parenting? Now, if the protection order is in place because it's highly necessary, because there's real allegations of abuse and the abuse is continuing, I agree. Let's keep the protection order in place, right? You can't sacrifice your own safety because you need to be able to co-parent with this other person. But it's important to consider, when there's a protection order in place, is it in place against each other because we're being petty or because we're being sour about the divorce? Or is it in place because there's a genuine need? If there's a genuine need, let's keep it in place and let's work around how the contact is going to work with the protection order in place, how we're going to navigate, who picks up, who drops off, how close am I going to come to you, how are we going to communicate with each other regarding the children. But if it's in place because we're being bitter and because we're being sour towards each other, I would highly recommend, and I highly advise those clients, when I do have them, to have the protection order set aside and focus on the co-parenting. You need to put the kids first, and you need to put their best interests or have their best interests at heart. Now, I've had a matter, and I have a matter actually where there is a protection order in place, and the parties have to co-parent. But what we've done is just to say, when there needs to be an exchange of the children, so collection and a drop-off, just ensure you keep your distance, because the protection order is against mom. We do ensure that a family member comes with her to come and collect the children, just as a witness, to say nothing happened, I just took the children from him and I got in my car. Insofar as the communication is concerned, I always just tell parties to communicate only regarding the well-being of the children. Don't ask them any other questions, because if you ask the wrong question or you make the wrong statement, you have the ability to be in breach of that protection order. So, yeah, at the end of the day, Merv, I think protection orders make it very difficult to co-parent when they're in place, but sometimes they are necessary, and we need to just navigate, working around them in the interest of the children having contact with both parties, I guess.
No, absolutely spot on, Leigh.
Yeah.
It's one of those things, unfortunately, folks, that we see quite a lot in practice, where protection orders are used with mala fides as a punchline.
Yeah.
What I've unfortunately seen numerous times is where a parent would get a protection order against a co-parent in respect of themselves, where there was no domestic violence towards the minor child at all, and the domestic violence was not even in the presence of the minor child, and they then used that as a mechanism to keep the child away. And now, obviously, not to detract from how heinous it is that domestic violence is a thing that exists. But there must be a very, very careful distinction. And this is where social workers have an incredibly tough job. And they really have to walk a balancing act between saying, there was this domestic violence between mom and dad, but to what extent will that then transfer to the child? And I must commend Joburg Family Advocates Office for the way that they've handled quite a few of these matters. Very, very sensible, very pragmatic solutions from some of the family counselors at Joburg Family Advocates Office. But yeah, it really is a conundrum. Children's court and domestic violence court often run together. Alfred, you've got your hand up, so I'll ask you if you can quickly, briefly just ask your follow-up question, just considering we are pressed for time, but go for it.
Thanks, Mervyn. Hello, Leigh. Thanks for the presentation. Diving straight into it. Yes, we understand the protection order in the with wearing glasses from the point of contact and that type of thing. But I'm more interested in what happens in a court situation where the parties have to both appear in court and there's a protection order in place. How do the courts deal with that, especially if if they can't be within a certain perimeter or they can't be in each other's company or as such? That must be like really a difficult situation, or they can't be near the kids. It would be interesting to know how the courts would deal with that.
Okay, so if you don't mind, Leigh, if I can just jump in there. I'm actually preparing a webinar, Alfred, for SARM. I'm assisting Ordinary with a masterclass in May on the legal frameworks of domestic violence. So, number one, let's look at what a domestic violence court can order. It can order that one doesn't commit an act of domestic violence, that you can't get another person to commit an act of domestic violence. It can prevent entry into a shared residence, into a workplace. It can order you not to prevent entry of your spouse. It can order contact under supervision or under certain terms with children, or it can prevent contact with the children. There is no mechanism apart from a catch-all, such other relief as may be required or something to that effect, that a court can say distance. Alessandra is quite right in pointing that out. We don't have this thing as we see in pop culture, not within 100 feet or whatever the case may be. So vis-a-vis one another, the parties would just have to behave themselves. You would have to be patently stupid to verbally abuse your spouse in front of a magistrate in court if there is a domestic violence interdict. In terms of the children, that is something that can be monitored. Generally, if it is in court, it is a very controlled and structured setting. So you do have the magistrate, the commissioner there. You do often have social workers. You very often have a court orderly in their full SAPS regalia, sitting either in the courtroom or just outside the door. So they really regulate their own proceedings as far as that's concerned. Right, but excellent question. Very, very important from a practical point of view. I want to quickly go up and deal with a very important question that was raised by Steph Dawson-Cossa, which I think we need to just quickly touch on, which I've touched on very briefly. Steph asks, in what way is legal aid, i.e. a legal representative, different from the voice of the child? Leigh, what I indicated to Steph in the chat box is, the VOC is an interview with a feedback, where you simply hear the voice of the child, whereas a legal representative, is an attorney acting for the child. Obviously, there is quite a bit of an overlap, because the child will give their views to their attorney. Have you seen this in practice? I know, for example, Meyerton Magistrates Children's Court has the legal aid person running in and out of court on a daily basis. I know there are a lot of courts that are quite, shall I use the word woke in that regard, who have the legal aid guys. They're kind of as a default. They are there if there's a case the child gets a legal rep. What have you seen in practice?
So I think in practice, from what I've observed, the biggest difference, Steph, thank you for the question, between the VOC and the legal aid representative acting on behalf of the child is really the report. With the voice of the child, there's actually a formal report that gets rendered on paper, black and white, and that gets submitted to court. But with the legal aid representative, they just have canvas, conversations with the children, and give feedback to the magistrate. It's not really in a report. I've never been in a matter, maybe my colleagues have, but I've never been in a matter where legal aid has actually formally drafted a report on what the kids have said. It's a conversation with the kid, and then it's a conversation with the magistrate, sometimes in open court, sometimes in chambers. So I think the biggest difference is also the VOCs, it's a work in progress. It's a couple of interviews with the child, and it's a lot more intimate, and it's got a lot more of a focused goal. Whereas legal aid, they sit there, okay, you need to speak to this child quickly, hear what the story is, come back and tell me the feedback, and that's where their mandate kind of ends. So I think the biggest difference, Steph, to answer your question, is one VOC is an actual report that gets rendered on paper, whereas I think with legal aid, it's just Canva conversations that happen. I hope that helps.
Absolutely.
Awesome.
If I can, without having been asked, also jump in, we must also be very careful as practitioners. Now, I know we've got a mixed bag of people in this webinar today, and it's actually so nice to have a mixed bag like this, because we can talk about, common parlance and what we deal with in a daily or on a daily basis. I've actually, I'm very good friends with a social worker who's also a mediator, who gets incredibly upset if one talks about a voice of the child in terms of litigation and her forensic practice. She says, well, you know what? It's not just a voice of the child. If you look at how the Children's Act is couched, it's child participation and taking into account the views of the child. Now, obviously, it's come into common parlance that it is a VOC, a voice of the child. But if we look at the legal framework doesn't say that a child must go and sit with an auntie or a and tell them what they want. The Act says that we must take into consideration the views and the wishes expressed by the child, having regard to their age, maturity, and stage of development. How that happens is very, very interesting. And for those of you who are interested, if you have a look at Prof. David Skelton's work on the topic, they actually posit that there are numerous ways to do that. A VOC is one, a forensic investigation is another. They go so far as to say even a judge sitting with a child, just hearing their views, or a magistrate sitting with a child hearing their views, can actually serve to deal with that requirement, that you must hear the views and the wishes of the child. Obviously, it's matter dependent, though, folks. Let's use, for example, this incredibly interesting scenario of parental alienation. What is the value of a voice of the child in a case? If we look at the I don't want to say accepted, but the actual overriding definition of parental alienation that we see, that there is this irrational aversion on the part of the child to having contact with the alienated parent. What is the value of a VOC under those circumstances if the child's testimony is tainted by this, what we can only term brainwashing, by the alienating parent? So it's a very important question, Steph, and it's one, unfortunately, that doesn't have a clear-cut answer. I think the answer, insofar as one can have one, is the purpose of it. A VOC, for all intents and purposes, is to give a report or just to furnish a version, whereas a legal representative is literally an attorney who acts upon the instructions of the child. And then you can take it even further, and and then you can go into the difference between a curator, curatrix ad litem, and a legal representative in terms of the constitutional right to legal representation of children. Leigh and I were involved in a matter years back where I was very fortunate to argue this point before Justice Jody Collopin, who's now gone up to Constitutional Court. And he gave us, incidentally, Joe, you're asking about the name of it. It's Davel, D-A-V-E-L, so Davel, actually, if I can let my Afrikaans go, and Skelton, and I think the work is a commentary on the Children's Act or something to that effect. It's either LexisNexis, Butterworths, or Juta. And I'm actually, a lot of what I'm sharing with you now comes from the judgment, which we got an extempore judgment, fantastic judgment, from Judge Collopin in that matter. The point is, it's not clear cut. There's so many ways to bring a child before court. And I think that's also, Leigh made the point earlier, guys, that the Children's Court doesn't have the rigid civil rules that we would see in the Magistrates Court rules. The magistrate or the commissioner has the authority to conduct the proceedings as they see fit. And I think it's sensible because you really need to deal with each family unit as it comes. And that's, unfortunately, it makes a lot of room for confusion. But it's cool. It gives me and Leigh some nice opportunities to chat to you guys. Isabel, you asked in terms of the matter in which he ruled. It was unfortunately an extempore verbal judgment. It wasn't a reported judgment at all. It won't be of much use. I can give you the heads that we submitted in the argument. I'm happy to do that. We'll just obviously have to redact the parties' names for their own protection. Okay, Khadija, thanks for being here. No problem at all. You're welcome. I'm glad to have had you here today. Leigh, shall we go over to the forms? Are you keen to run through the form too?
Yeah, we can, Merv. I just want to get a hold of, I had the form here. If you give me 1 minute.
Okay, no problem at all. Folks, while Leigh is getting the forms ready, have we got any other questions which anyone would like to raise? And please, can I ask you guys, I think Leigh has done such an amazing job today. Not to flatter her, it's her first time riding solo on one of these webinars, and I know she was nervous as hell. Can we please all just give her some love? Because I really, really think she did such an excellent job today. I really want to commend her. This means I probably can start chilling out and I don't have to do so many webinars in future. Haha. Right, Leigh, how are you doing? You got your forms?
Yeah, I'm clicking on it now. If you give me 1 second.
Excellent. And then you're just going to have to share your screen. I see we've got a hand up. Esther, how are you doing? All the way from Richards Bay, ne? Esther, you're muted. Let me just see if I can unmute you. You're going to have to unmute yourself, I'm afraid.
Oh, I'm in Matuba. It's far from them. I'm in a very lonely place.
Anything outside of the West Rand Triangle in Gauteng is Cape Town to me, I'm afraid. So welcome all the way from Matuba, also known as Cape Town. What question have you got for us?
I just want to really say thank you for Leanne. I'm dealing a lot with Children's Court. And being where I am, it's so difficult. And I would like to know, Mervyn, if we have answers about Children's Court or problems, whether she will be willing to assist and help in that. And thank you so much.
I'm sure she would be happy to have a cup of coffee with you and discuss. Hey, Leigh, if I can take your name in vain.
Definitely, Merv. I'd be more than happy to help.
Wonderful. Excellent. Thanks, Esther, for the feedback.
Thanks, Mervyn.
No problem. And then Isabel, I'm so pleased that you're in with us today. I'd actually love to connect with you and find out a little bit of the work that you do with your NPO, but you've got a question for us. Please go ahead.
Thank you, Mervyn, and well done, Leigh. Your presentation is very informative and very instructive. So my question is regards to parental alienation. So I know it's in terms of the Children's Act. I struggle with where to find the definition of parental alienation outside the law. Yeah. I say this because in the Children's Act, we talk about exercising parental responsibilities and rights. And when you look at the literature, I'm sorry to sound so academic, it's more from a psychology, perspective. So I really liked your question when you said, what is the value of VOC in cases of parental alienation? So I wanted to hear your thoughts on legally, how do we define parental alienation?
Certainly. Okay. So there are a few things that you need to bear in mind. I know some of our attendees have seen my slides, which I distributed. I did a webinar on parental alienation a few weeks ago, and I've actually, I don't want to take her name in vain, but I've managed to convince a very, very clued up social worker to do a Q&A session with me on parental alienation in the next coming weeks, which I'll obviously distribute to everyone on the mailing list and in the WhatsApp. Long story short, Isabel, it is a contentious issue. So the closest that we have in terms of a psychological definition you can find in the DSM-5. Leigh, you're sharing your screen, so I can actually see myself talking here. It's a bit weird. Thank you. That's a bit less awkward. Thank you very much. The closest that we've got in terms of a medical definition, Isabel, is in the DSM-5, which doesn't really encapsulate, and then we've also got the ICD-11 definition. Then we've got, so DSM-5, I'm just quickly opening my slides over here, then I can tell you what the definitions are there. In the DSM-5, we have what's known as CAPRD, a child affected by parental relationship distress, which is defined as this category should be used when the focus of clinical attention is the negative effects of parental relationship discord, e.g. high levels of conflict, distress, or disparagement from the child in the family, including the child's mental or other medical disorders. That's the DSM-5. And then there is the World Health Organization, the ICD-11. It always used to be the ICD-10. The ICD-11's come out in January this year, which is QE 52.0, caregiver-child relationship problem, which is a substantial and sustained dissatisfaction within a caregiver-child relationship, including a parental relationship, associated with significant disturbance in functioning. And that's from the ICD-11 definition. But I'm sure you'll agree that neither of these definitions really hit the nail on the head. It doesn't tell us exactly what it is, and there's such unfortunately misunderstandings around parental alienation amongst a lot of people, even prominent people in the legal profession. We've seen some interesting judgments come out of some courts, which I don't necessarily agree with. And then we've also seen some, on the other side of the spectrum, legal representatives say, you know, there's alienation when it's just a parent not allowing contact, when it's just good old withholding contact, which is not parental alienation. The three closest definitions I've got come from Fiddler and Bala in 2010, Warshak 2006, and Burnett, Wambold, and Narrow in 2016. Follow some of Burnett's work, B-E-R-N-E-T. It's quite a big champion in terms of parental alienation. It was Burnett, as far as I understand, also who was at the forefront of trying to lobby the APA to include parental alienation in the DSM-5, which they then partially did, but not really, this is the most concise one, is Burnett, Wambold, and Narrow 2016. They define parental alienation as a child's reluctance to have a relationship with a parent without good reason. Generally, when you see those two aspects, there must be an aversion to contact from the child and this demonization of the alienated parent, and there must be no rational reason. If there is a rational reason, then it's not alienation, then it's estrangement. For example, I don't want to see dad because dad is a druggie and he gives me a smack every time he sees me. That's not alienation. But if dad is loving and the child and the dad have always had a good relationship, now all of a sudden after the split, in a question of 2 months, all of a sudden the child wants nothing to do with dad. Even when contact is ordered, the child remains averse. Then you've potentially got an alienation thing. Understand, however, folks, to everyone in this session, it is an incredibly complex topic. Don't try to fully understand or encapsulate or master parental alienation, because the jury's still out worldwide on a coherent definition. But Isabel, please do reach out to me. I'm happy to share my slides with you. I know Ornay did also distribute it to the attendees of their parental alienation course, which Leonie Hennig did. But anyone else who also wants my slides, please do. Yeah, Ilse, it's interesting that you talk about PA and PAP alienation, parental alienation syndrome. And PAS, yeah, it's fallen out of favor. They don't talk about it as a syndrome anymore. It's just such a complicated thing. But yeah, if there's enough interest, maybe we'll do another webinar on that in the coming months. Yeah, but those of you who'd like my slides in the interim, please let me know. I see we've got one more hand up, which has been up for a little while. Esther, I think it might just be that you haven't put your hand down, or have you got another question for us? And then I can hand over to Leigh to go through the form 2 with everyone who's interested. Right, gone. Okay, right. Leigh, over to you. You can deal with the form 2.
Thank you so much, Merv. Alrighty, so this, I think hopefully you can share or see my screen. This is the form 2 that we use to refer a matter to children's court. Now, something I want to draw your attention to is the small print that we don't normally read, right? The terms and conditions. Before I get into what you need to fill out in the form, if you see here, point 2, it says your attention is drawn to the fact that the children's court may adjudicate upon the matter, refer the matter back for mediation to a lay forum, or refer the matter for a family group conference. Okay? If the matter is referred back to children's court, the clerk will inform you accordingly. So just bear in mind, if you submit this form 2, it doesn't mean that you are going to get a court date or that, you know, the court is going to hear your matter in court formally. It may be that the court sees that there's a possibility of settlement in this matter and then refers the matter, for example, to mediation. So just bear that in mind. There's several outcomes that can happen with submitting a form 2, but I'll tell you this much. Every time I've submitted a form 2, we've received a court date for the parties to appear and for an investigation to happen. So let's quickly go through the form. Now, the file number here is basically going to be your case number. So this is not something you would have to complete. This is something that the clerk is going to complete if you get a case number and your matter is lodged formally at children's court. Then part A is particulars of the children. So this is putting the info of the children. So if there's 4 children, you're going to put all their full names and their genders. You're going to put their date of birth here. And you're also going to put the residential address. So where do the kids reside? You're going to put some telephone numbers there. If the kids have their own phones, put some numbers there. And then if they don't have any cellular numbers, you can just put the numbers of the parent with whom they are residing. Then physical address, this needs to be the address where documents can be served. Okay, so you need to make sure that the address that goes in here is the address where the police is going to be able to serve documents on them. Then this section here says so this is still under part A. This section says other relevant information such as financial position, availability of transport, socioeconomic status, and if an interpreter will be needed, etc. So it's important that you put here what is the financial position maybe of the parents who's taking care of the children. How does transport look, you know, of the person lodging the court application? Will you actually be able to get to court? Can you afford to travel to court every time? This just also helps, you know, the justice, I would say the justice system to assist parties who also don't really have a lot of money to litigate. Okay. Then particulars of, so this is always the complex part, right? Part B and part C, because we never know whose particulars must go where. So this is particulars of, okay, look here what it says, particulars of a person acting in the interest of the child or on behalf of the child who cannot act in their own name. So whose details go here? In part A, we know it's the details of the children. In part B, it's the person referring the matter to children's court, so the applicant. So if you're a mom and you're referring the matter to children's court, mom, your details go in part B, okay? Or if it's dad, your details go in part B. All right, so you'll then put your surname, your first names, your ID number, and your date of birth. Then capacity of the relationship of the person acting in terms of section 53(2). So you would just say whether you're the mother, whether you're the father, whether you're auntie, the uncle. So what is the nature of the relationship you have with the children? Then this is not necessary. You know, the registration number of body, corporate, that's just, it's really not necessary to complete that if you're a lay person that's completing the form. Then you need to give your residential address, mom as the applicant or dad as the applicant. You need to give your cell number, your work address, and also your physical address where documents can be served. Now, it's important that you give accurate information in this form, okay? This form assists the court to make contact with you when they receive your application, to call you if necessary, to ensure documents are served on you personally at your address. So please do not lie on this form. This form is also a form completed under oath. So you need to be very truthful in this form. And you then also need to put in your email address. Some of the courts communicate via email, which is also very useful. So just ensure your email address is correct. Then part C, particulars of the person having an interest in the matter. Now, we know part A is the details of the children that get completed. Part B is the applicant's details, so mom who's referring the matter or dad who's referring the matter. Part C is the other party's details. So dad, if you're the one referring the matter to children's court, you would put mom's details in part C. Mom, if you're the one referring the matter to children's court, you would put dad's details in part C. So who's the other person that's going to be affected by these proceedings? Okay. All right, so their details are going to go in part C. Again, you're going to put whatever details you have of them. If you don't have all the information, just leave it blank and tell the clerk that, but you need to give as much information as possible, because they'll need the contact number in case the court wants to call them. They'll definitely need a physical address so that documents can be served on them. And then you'll also hear in terms of capacity of person acting in terms of section 53, you would say what the person's relationship is with the children. Then there's a second part C here. This is just if there's more than one person that's going to be involved. So if there's a granny or a grandpa that's going to be affected by the proceedings, you would also put in their details. And normally it's just, you know, mom and dad. Or if it's two grandparents and one dad, you would just put in their other details here. So the person who's affected by the proceedings and who will have an interest. Then we get to the interesting part of the application. This is part D. Okay, so this is the particulars of the matter. Now, it says here, nature of the matter brought to court. So the court actually tells you here, please give full details of the matter. So are you applying to have a parenting plan registered? Are you applying for amendment of a parenting plan? Are you applying for the removal of a child to safe care? Are you applying for a child to be found in need of care and protection? Are you applying maybe to have a child placed in a youth care center? Or are you applying for adoption? So you would state there particularly what is the relief that you are seeking, okay? It's very important that you put the relief there so the court understands what is the nature of the application that they are dealing with. Then the next portion here are documents, okay? So are there any other documents relating to the matter? So normally what I do when clients complete a form 2 and we do a supporting affidavit, if we have a supporting affidavit drafted and signed by the client, I would just say here, see affidavit attached. But if you don't have a affidavit that's being drafted by an attorney, you would need to get, there's like a sworn statement form that you can get from the clerk that, you know, you'll write on, you'll place your affidavit on that form and then the clerk will commission it for you. So if you have an affidavit attached, you would write the affidavit attached. If you don't have an affidavit attached, you would just say sworn statement attached, for example. And then the other documents, and I said I would get into this. What are some of the other documents that you would need to submit in support of this form? Now, when you go to children's courts, it's very important that you take along a certified copy, and please note, I'm saying certified, certified copy of your ID as the applicant. If you have a copy or a certified copy of the respondent's ID, that would help. And then you would need the birth certificates of the children, again, preferably certified copies, and then your supporting affidavit. That can either be a formal affidavit drafted by your attorney, or it can be a sworn statement which you've written out and the clerk has commissioned. So those are the main documents which you need to attach to this form. But, you know, if you're, for example, applying for an amendment of a parenting plan, it may be wise to attach the actual parenting plan which you want amended to the form. If you're applying for the removal of a child to safe kill, or applying for a child to be found in need of care and protection, maybe in support of your affidavit also, and also annexed to this form, you could submit maybe proof of why the child needs to be found in need of care and protection. So every application is different, but you know, I think the main documents to attach is an affidavit, a sworn affidavit in your name, together with your ID document, the ID document of the respondent, if you have that, and the birth certificates of the children. And as I've explained earlier, this is a document completed under oath, so please do not lie on this form and ensure that it is commissioned properly in this portion here by a commissioner of oaths. That can be an attorney's firm, the police, the clerk of the court, any person that holds the authority of a commissioner of oaths. So I hope that was helpful. If you still struggle to complete the form, you can reach out to me and I will assist accordingly. And if you need a copy of the form, you can also just let me know. Thanks, Merv.
Excellent. All right. I think what I'll do, I see we've got quite a few people still in. Thank you for that, Leigh. That was very, very helpful. Have we got any further questions? I know everyone was paying quite close attention to Leigh going through the form, so I haven't seen any questions come in being typed up. Can I please have, if we have any questions, some hands up? There we go. I see we've got the first hand going up. Stella, how are you doing?
Good morning. I was busy typing, so I thought let me rather ask. Thank you so much, Leigh. That was such a nice webinar. I learned a lot. I just want to ask, so with the Form 2, say for instance, it's not a divorce, the couple were not married, parenting plan has been endorsed by the family advocate, but we just want to make it a court order. With the Form 2, do you still need, so the parenting plan, everything is signed off, agreed. Do you still need an affidavit as well?
So I would just submit an affidavit and state that the parties have entered into a parenting plan and that they would require the same to be registered or made an order of court. So it's just to confirm under oath that we are indeed the parties who have signed this parenting plan. It would be a very short affidavit, you know, nothing too lengthy. Just to confirm, we are the parties who signed this parenting plan. It was agreed upon and signed on this date, and we want it to be made an order of court. So a very short affidavit, probably not even a one-pager, not even half a pager. But I think it's important, or you can even, you know, put that on the form. There where it says documents to be attached, you can just say that we want the parenting plan to be made an order of court. Then obviously for it to be made an order of court, the parties would both need to appear to confirm their signatures. And to confirm that they're both in agreement for it to be made in order.
Okay, thank you so much.
There's one thing, Stella, which I would just also caution you, if I may jump in, which I generally, if I take a parenting plan to the higher court, also make a point of putting in my affidavit is just the child participation. What steps have been taken to ascertain the views of the child in accordance with their age, development, well, age, maturity, and stage of development. If you've got a VOC report, maybe attach it as an annexure. And obviously your regulation, your forms as well. Hey? Your form, what are those forms? The Form 8 and the Form 2 and the Form 30 and all of those fancy ones that you mediators use. Great, excellent question, folks. Any other hands go up? Clarabelle, I see your hand is up.
Good morning, Merv. Good morning, everyone. I just wanted to ask, Stella now mentioned that if you have a parent plan and it's been approved by the Family Advocate's Office and then you want it to be made an order of court, do you have to, if the two parents agree and they both sign the parent plan willingly and they do the affidavit, can you just take that directly to the Children's Court to be made an order of court, or do you still have to go via the Family Advocate's office?
Look, as I understand it, sorry, I know Leigh's just got some problems with her camera. My experience is mostly in terms of doing it through the High Court, but I would surmise, if you have a report, if it's been registered, the Family Advocate has by proxy already approved it, or if you've got an endorsement, then I would go simply to the court with that endorsement in hand. Remember, if you go and look at SOLO, which I referred to earlier in the chat, Satchwell does a very good job of setting out the job of the Family Advocate. And remember, the Family Advocate is a functionary of the court. They're not a party to the proceedings. They are not a witness to be subpoenaed, for example. They are a functionary, and the court, well, the High Court is obviously the upper guardian, but the Children's Court has the powers to make an order in accordance with the best interest of the children. And if the Section 7 is not an issue, if the provisions are reasonable, and I don't think you'll have any problems. Leigh, do you want to add there? I see you're back. Thank goodness.
Sorry, yeah, the internet's a bit unstable. Load shedding, yeah, I apologize. But yeah, so remember, with a parenting plan, you can either get it registered by the Family Advocate or get it made an order of court. We obviously always go the route of making it an order because it's more enforceable. But yeah, you've got two options. If it's already endorsed by the Family Advocate, it's very quick to make it an order because the Family Advocate technically is the one that needs to approve the parenting plan. So yeah, that's it from my side.
Excellent, thanks, Leigh. Stella's got another question for you.
Sorry, forgot to ask this. So with the affidavit, I just want to know, would it be okay for me to do, because I'm a commissioner of oath as well, but I'm the mediator, to let them do affidavit with me?
I think you will a kans vat.
Yeah.
Well, the thing is, Stella, I can honestly,
if both parties signs it.
The thing is, I can color my hair pink and get 3 nose rings. I can. Is it going to be a good idea, though? That I think is the answer that you need to look at. I don't think there's anything in. Yeah, I would avoid it, to be honest with you. I know a colleague of mine has been naughty previously and had the Family Advocate Annexure A, commissioned by a co-partner in their firm or whatever. But I would avoid it if at all possible. I see Alessandra has also indicated from her perspective as a former acting magistrate, rather not. I think you're opening yourself up to potential heartache where it's actually very, very simple to just avoid it. Remember, you've got a stake. If you were the mediator, you have to also make your declaration that you mediated the dispute, and then if you now commission the affidavits as well, it just you are non-partisan from a mediator point of view, but if you are the Commissioner of Oaths, you're in a completely different capacity, and you still have, once that settlement is reached, or the parenting plan is signed, you've got a vested interest in not wanting this thing to be queried or whatever the case may be, or that can be inferred. So I would advise rather not to.
Okay, thank you.
No problem at all. Elaine asks, VOC from which age? Elaine, can I ask you to perhaps just clarify the question? If you want to maybe just switch your mic on if you're comfortable doing so.
Hi, Mervyn.
Yes, we've got you. We hear you loud and clear.
Thanks. Yeah, I was just wondering about the voice of the child. I mediated parties. I think the child is now, is she 4 or 5 years old? So from which age do you get the voice of the child?
That's a very, very good question. And there's no hard and fast rules as far as I'm aware. I know we've got one or two social workers in, and I'm actually going to ask them. I'll give you my view, Leigh can give her view, and then we'll ask the social workers among us to come to our rescue if they want to perhaps chime in. Remember what the Children's Act says. The child's views and wishes must be taken into consideration, having regard to their age, maturity, and stage of development.
Yes.
People are not formulaic things. So, for example, my daughter is now 4 years old, going on 16. She can honestly talk the works of Dostoevsky, but she's got friends in her class who struggle to string a sentence together.
Yes.
Would you comb those two children under the same comb? I've got a family member who's got a 13-year-old child who unfortunately suffers from Down syndrome and Asperger's together with that. That is a further confounding variable. So I think the legislator was very clever when they put that caveat in of having regard to their age, maturity, and stage of development. I think they got this thing that there isn't really a rule of thumb when it comes to kids. I think one of the overriding factors would be to what extent the child is able to express themselves. So if the child can't talk, it's obviously very, very difficult.
Yes.
Or if the child has a very limited understanding of language. In my opinion, like I say, my daughter is 4. If someone were to ask me if she were to go and tell someone who she likes, who she doesn't like, what she wants to do, what she enjoys doing, I would say no problem at all. She can tell you, but it's all going to be ponies and horses and princesses. If you ask what she wants to be when she grows up, she wants to be a horse, literally. So, Leigh, what's your views on that? And if we've got some social workers still in, I think we have 1 or 2 still in, we can perhaps chime in on that.
Yeah, so I think I definitely agree with what you're saying, Murph. There's no set age. Kids obviously develop at different stages in their life, and each child is to their own. But I think the other important thing that we must remember, and this is really where we would need the professionals to confirm. I know a lot of the professionals that do voice of the child or interviews or assessments do age-appropriate assessments. So, if you're 4, they'll do an assessment that is really suited to a 4-year-old. If you're 13, the assessment would be very different because you can now speak and you can actually say what it is that you want. So there's no age. I agree with you. And it's really dependent on the development stage of the child, and the maturity is a big one. Yeah.
Okay. Thanks, Leigh.
Absolutely.
Thanks,
yeah, no problem at all. Okay, so we've actually got a few interesting people that have chimed in here. Ilza says the voice of the child assessed, their voice can be heard even as toddlers depending on the correct assessment done. Yeah. Absolutely. Steph says, having just finished her VOC training, they were told to consider open quote, close quote from 3 years old. But I suppose there's also a big kind of caveat in discretion. Joe says there are ways to ascertain the children's views and wishes even if they are very young. For example, using the child's voice toolkit, which was developed by, and you're talking about Duchen and Schutte. I'm assuming that's Ronald Duchen, who I've got a lot of time for. I'm not sure who Schutte is there. And age appropriate is crucial. Yeah, I think Irma Schutte. Okay, thanks, Joanne. So yeah, look, I think that this is highlighting back right in the beginning, the point that I made. It's so important for us to talk between professions because it's an important question. When do you send a child for VOC? I know of cases where Leigh was involved, and perhaps she can elucidate for us, where the parties walk out of court, do a parenting plan, and the magistrate calls them back and says, listen, come back. I want to make this thing an order of court. And you kind of want to say, well, what about the family advocate? And the court says, no, I'm ready to rock and roll. Alessandro says the presiding officer would establish the competency of the child. Absolutely, using pretty much what a court would use in establishing competence of a child witness. Yeah, good point. Consider whether someone is competent to testify with that toolkit, if we can call it. All right, Stella, I see you've got your hand up again. I'm going to start billing you, sister. But if you're lucky, I bill you in coffee.
Sorry, it's an old hand.
It's not, that hand's not that old. I've met you enough times to know that hand's not that old. Any other questions, folks? Please don't be shy. We're in the last stretches of this meeting. I see slowly but surely people have been going off to weekend mode. I would hate for any questions to be disregarded before we wrap up. So let me ask this question to Leigh, and it's a very, very difficult question. It's one I suspect she'll answer very, very diplomatically. What's your take on the children's court? Does it work? Does it not work? Is there room for improvement? And now everyone's ears are pricking up, being like, no, I'm going to make poor Leigh say something controversial and end her career in one fell swoop. But what is your experience on the ground floor of the Children's Act? You know, of Children's Court, not Children's Act. What do you see?
So I think, Merv, to answer your question, I've experienced Children's Court that function really well. And I'm not going to say which courts those are, because I've also experienced Children's Court that functioned very poorly. The Children's Court I'm currently litigating out of, the first time we approached them, zero urgency. Second time I thought, you know, cool, maybe it was just a bad time of the year, but we approached them again now in urgency, still no urgency. So I think the Children's Court, the intention is to function well, but it's really dependent on the presiding officer in that court, who needs to run their court well. And I think Alessandra can agree with me on that point. If the magistrate is not in control of their court, the court is a mess. So yes, I think it functions well for the most part. It's a very frustrating process or court to work through, but if the magistrate is hard on their court and they function well as an individual, the court will function well. So I don't know if that answers your question. Yeah.
Let me be the controversial one. It's a lucky packet, isn't it?
No, 110%. I'll tell you something. The Children's Court in Kimberley was phenomenal. It was clean. The magistrate was on top of his game. He knew what was going on. The clerks were passionate. But then I get to a court here in Joburg, and I'm not going to say exactly in which area, and I'm shocked because there's no urgency. And I'm like, how does this court function, and why does it function like this? But again, the magistrates need to take control of their own courts. That's my statement.
What's the role, do you think, you know, in terms of what we see in the Children's Court? What do you think is the best way for practitioners? And I'm talking about family practitioners. I love using that word because we're all practitioners who work within family units, whether it's in the law, whether it's in negotiation and persuasion, whether it is in mental health. We're all family practitioners. What can we do to better serve families, you know, having regard to this lucky packet thing at courts? Sure, guys, I'm really being nasty to Leigh. I think she did so well that I really want to make her a bit nervous before I let you guys go off to 4 minutes from now.
All good. So, Merv, I think it's to really work together as a unit. Understand that the magistrate, the social worker, the clerk, the stenographer, the legal aid person, the family advocate need to work as a unit in helping that family. And I've got a matter like that now in Germiston Children's Court. You know, the social worker and I are working so well together to bring this family relief in the form of a parenting plan. And I think that's important. Attorneys mustn't separate themselves from the situation. Magistrates mustn't think that they're more important. Social workers mustn't think they don't have to work with the attorneys for a solution. Us as the officers of the court need to work as a unit to bring relief to the families and also guide them along. They don't understand the process. They can't always be reasonable and rational, and we need to pull them in line where it's necessary.
Wonderful. Guys, right, on that note, I do want to encourage all of you who have not yet gotten in touch with me to form part of our WhatsApp group. Please do, if you're a family practitioner, get in touch with me. I am becoming very militant in enforcing rules against spam. No messages after 7 in the evening, no messages over weekend. And I find there's a lot of free flow of information there between professions, all the way from senior counsels to us humble attorneys, to psychologists, social workers, and our dear friends, the mediators, who we always love having on board because they make our lives as attorneys so much easier. So please do reach out to us. Let's keep this conversation going, folks. Thank you for taking an hour and a half, in fact, 2 hours out of your Friday to go on this learning journey with Leigh and myself. And if anyone has any suggestions for webinars which they would like to see in the future, please pop us an email, mervin@vermeulenlaw.co.za or leigh@vermeulenlaw.co.za. Please do alert us. We want to keep this free flow of information free, and we want to expand the knowledge base between all of us as family practitioners. On that note, thank you once again for joining us. Have a fantastic weekend, and we look forward to seeing you for the next one. Cheers, everybody. Thanks, Leigh. Well done.
Everyone.
The information contained in this video is distributed free of charge for educational purposes. Whilst we have taken all reasonable steps to ensure that the information contained herein is correct and up to date, insofar as the law in South Africa is concerned, the law remains a nuanced and complex field of study, replete with many exceptions and conditions. Please, therefore, do not utilize this information as legal advice, which it is not. When in doubt, consult with a legal professional. For more information, please feel free to contact our offices.